All right, we're probably going to hear very similar arguments on this one too. Just heard. Okay, so Tilsith, et cetera, versus Gondolier Properties et al. You're up, Mr. McKee.
Thank you, Your Honor, and may it please the court, Jim McKee on behalf of the appellants in this particular case, Joel and Tilsith and the related entities. I do want to reserve 5 minutes for rebuttal, if I could, Your Honor. And I should mention, I did not appear on the screen, but I was listening into the previous argument, so I will do my best to not rehash arguments.
This one was going to be real short, is what you're saying.
Not sure about that, Your Honor, but I will do my best. Your Honor, just to begin with, I think let me phrase or frame this case, if I could, for Your Honors. This is a case about disputes between family members over business agreements and the compensation to be paid pursuant to those business agreements. Now, certainly, during the course of the case, certain allegations were raised of a bit of a nefarious nature, but at its core, it remained a case about disagreements over business arrangements. There's two, we've raised in our brief a number of reasons we think reversal is required, but two primary things I'd like to focus on here. First is the arbitration issue that obviously your Honors have already heard quite a bit about this morning. And second is the civil theft issue as it relates to Ms. Tilsith and her related entities. And the issue there is that the verdict we would submit, Your Honor, does not comply with Florida law. And what we mean there is that it did not include a specific finding that was required to be made by the jury pursuant to Florida law. So first I'll touch on the arbitration issues. I think as I believe Your Honors have recognized, I think we need to start from the proposition that the statute and the rule, which obviously implements the statute, they impose what I would call I would refer to it as a non-discretionary duty on behalf of courts. If there is,
yeah, they do. But the thing is like the statute never says it has to be in writing, and indeed it can't, because that's a procedural question, and that's within the realm of the Supreme Court. And the Supreme Court's rule says a motion. No, it says actually, if a motion has to be filed, and then if a request is not made. But even if you consider a motion, if you look at Rule 1.100, a motion has to be in writing unless it's made at a hearing or trial.
Well, Your Honor.
So we have a judge here who says, I remember you said, yeah, we want a trial. So there it is. I mean, how do we get around that? We don't have anything that contradicts that.
Absolutely, Your Honor. So first, the rule, I would point out that the rule does speak to filing a motion for trial,
yes.
and then says if a motion for trial is filed by any party, it repeatedly speaks of the term filing. And I think
on the other hand, it says you're only entitled to a judgment if no request is made. That doesn't say anything about filing the motion.
Correct, Your Honor, but I think we have to read the entirety of the rule in peri materia. I would admit to you that
actually you have to read the whole set of rules of civil procedure in peri materia, and that includes Rule 1.100.
Absolutely, Your Honor. I certainly don't disagree with that.
Right.
But as I believe Judge Atkinson recognized in his De Acosta dissent, there is an open question as to what is meant by the term filed. Is an oral motion enough? Is it enough when it comes to arbitration, when you've got a statute that says you have a right to have the arbitration award enforced as a final judgment if no request for trial de novo is made, and if the rule says you may file a motion, but if you don't file a motion, the judgment becomes final, the order becomes final. Can somebody come in and say, well, I'm going to make an oral motion and that's going to be fine? I would submit to you that is not sufficient under the rule.
So you want us to write that in an opinion?
I didn't catch that, Your Honor. I'm sorry.
You want us to write that in an opinion?
I believe you could write an opinion that says that
we would be the first one out there. I think I'd let Judge Atkinson write that maybe.
I'm not sure there are any court decisions going the other way, Your Honor. I'm not sure there's any court decisions out there that say that the oral making of a motion for trial de novo satisfies the statute or the rule. So
Steinberg. Wasn't Steinberg the one that let's see here. the, um, they requested a trial date in open court.
At the Nicholson Kenny case, Steinberg. Yes.
Oh, yeah, sorry. Yeah.
That's,
Yeah.
everybody calls it something different.
we can call it Steinberg. I know what you're talking about now.
So I think Nicholson Kenny versus Steinberg would be that case. No.
It may be, Your Honor. I'd have to go back and look at it, but I believe the Steinberg case, as with the De Acosta case, really centered on the waiver issue and on this issue of gotcha litigation tactics. And I would like to touch on that. Let me finish up on the oral motion issue. One thing I would ask Your Honors to go back and look at is what the court's order denying the motion to confirm the arbitration award actually says. Obviously, as Your Honors have already heard this morning, the court went back, listened to the security tapes because there is no transcript of the February 26th hearing on the motion to dismiss. I would submit to you that what the court transcribed there, and certainly the fact that the court went to this length is admirable. But there's nothing in what the court said there that actually constitutes a motion for trial de novo. Counsel never said, Your Honor, we moved for trial de novo. In fact, if you read to the end of this, the back and forth, what the court says at the end is, it's not in there. He says, hey, you might have thought you moved for trial de novo. It's not in there.
Yeah, but it's not in this writing.
Correct.
Right. Doesn't mean that what they said isn't sufficient to constitute a request for relief under the motions rule.
Correct. And my point, Your Honor, is I think there's also, I think this might be a slightly different case if the back and forth there recited that counsel for the other side said, well, Your Honor, we are moving now for a trial de novo. That's not in there. He said, well, we were supposed to include a trial de novo in the written pleading. Court says that's not in there, puts them on notice. Hey, it is not in there. You have not filed a request for a trial de novo.
And so therefore you can't get one unless you file a written one.
I didn't catch the first part, Your Honor.
So the implication being that the judge was saying you can't get a trial de novo unless you file a request in writing.
I think that's a fair characterization, Your Honor. I don't think there's anything that the court said to sort of sucker the other side in, if you will, into not filing a motion for trial de novo. I can tell you if I'd received this order and read this order, the first thing I would have done when I got back to my office was file a motion for trial de novo.
Perhaps, but you know, we're not here on that hypothetical. We're here.
Understood, Your Honor. A couple other points I wanted to make on arbitration. In the De Acosta case and I believe in the Nicholson Kennedy Steinberg case, certainly in De Acosta, one of the issues that the court considered, one of the facts that the court considered was that the case had already been set for trial, and the issue there is, well, is it sort of a gotcha to not or to actually enforce the statute and the rule? Here, the case had been set for trial, but I think it's very important to look at two things. One, the order that referred the case to non-binding arbitration. This is in the record at page 1329 to 1330. There's two different places in that order. The first place, bold, underlined, first paragraph says, please note that although an order setting this matter for trial may have previously been issued or may subsequently follow this order, it is only for purposes of placeholding and finalization of deadlines in the event a party timely moves for trial de novo. If a party fails to properly and timely move for de novo, any such reserved dates for trial will be canceled and the judgment entered in accordance with the arbitration decision. The actual order,
but that didn't happen here, correct?
I would submit to you it did not happen here. No party moved for a trial de novo. And then the order.
But the case wasn't removed from the trial docket.
That is correct. That is correct. The other document I would point you to is the order that actually set the jury trial. And this is immediately following that order. This is pages 1331 through 1336 of the record. And it says uniform order setting jury trial, pretrial conference, and docket sounding as placeholder when non-binding arbitration has been ordered. And then on the second page, it includes that same all caps, underlined, bold language, putting the other side on notice if you do not move for trial de novo, this trial date will be.
But even if it, whatever was put in that order, it's not determinative. They're not, the other side is not suggesting they did not know they had an obligation to seek a trial, after the arbitration award. So whether they put it in that order or not has no bearing on what our disposition of the case is. The rule and the statute put the parties on notice of what they need to do.
I think that's right, Your Honor. But the De Acosta case,
when all else fails, read the instructions.
Well, certainly, Your Honor. I think they should have. But the point I wanted to make was that in the De Acosta case and then the Nicholson Kennedy Steinberg case, part of what those cases centered on was waiver, that the other side had done something to kind of sucker in the other side into not moving for a trial de novo. My point here is there's no gotcha. There's nothing that the Tilseth defendants did to sucker the other side into not moving for a trial de novo. In fact, I would say the exact opposite. They were put on notice repeatedly, even by the trial judge. Hey, you need to move for a trial de novo if you want to move forward to a trial. I will move on to
and yet the judge moved forward to trial.
He did, Your Honor, and certainly based on.
The judge was of the view that they did request a trial de novo.
I believe what the judge stated in his order was that he thought they had expressed an intent. He said, although it essentially was stated on the proverbial record that the intention of plaintiffs was to proceed to trial. That's kind of what he centered on. Well, we think there was intent to proceed to trial, but Your Honor, I would submit to you that does not comply with the rule or the statute. And it puts
let me come back. Let's your side, and Mr. Coleman making a similar argument. This is that we have to construe this so narrowly that if you don't jump through precisely the right hoop, you lose your right to a trial. If we start construing this rule and statute so narrowly and specifically that way, or construe the loss of the right to a jury trial so broadly, don't we risk venturing into an unconstitutional area here where no one, they have been sent to arbitration. The reason it's not binding is that no one can be compelled to go to arbitration unless they've agreed to it, right? That's why it's not binding. So, and the reason it's not binding is because you can't be compelled to lose your right to a jury trial. If here these people filed a document so we reject the arbitration, and they said in the hearing, according to the judge, we want a trial, we intend to have a trial. If we're going to ignore all that because it was an I wasn't dotted or a T wasn't crossed on paper, aren't we doing some damage to the right to a trial? Courts will always be open. It's under in the Florida Constitution. Aren't we obligated to do otherwise in these cases?
I'd say, Your Honor, that this goes further than failing to cross a T or to dot.
I don't know. You guys haven't said, how in the world were you prejudiced in terms of your preparation for trial, in terms of your defense of the case? I just don't see it.
Let me give you this analogy, Your Honor. Certainly, we had a right to file a notice of appeal. We had a right to an appeal before this court. If instead of filing a notice of appeal timely, I had filed a notice of rejection of trial court final judgment.
You know what? I imagine under the case law, we would have construed that as a notice of appeal. Because if you look
absolutely,
at the case law, if the other party is put on notice of your intention to seek appellate review, that's all you got to do.
And I think the question there becomes, Your Honor, where is the line? I think there's a slippery slope, and I think there's a.
I think maybe that is what my question is, because if we draw that line too far one way, don't we risk depriving parties of their constitutional right to come into court for redress of their grievances?
I would point you guys, Your Honors, to one other case, the Johnson v. Levine case, which is a 4th DCA case. In that case,
they make a lot of trouble down there in the 4th.
They certainly do, Your Honor. They've spoken quite a bit about this arbitration issue.
for both sides here.
True, Your Honor. In the Johnson v. Levine case specifically, the defendants had filed documents that were purporting to be exceptions to the arbitration order. And the court there said, you didn't file a motion for trial de novo, do not pass go, you don't get a jury trial. I think that might help with where is the line. Well, if somebody says we take exception to the arbitration order, you can't just take exception to an arbitration order. Shouldn't that have been construed as a motion for trial de novo? Shouldn't that have been construed as them being entitled to a jury trial? The court there said no.
Were the exceptions in Johnson versus Levine, akin to the exceptions from magistrate's order or from, an administrative law judge's order? They're specific to certain findings within the order, as opposed to, in this case, a complete rejection of the arbitration award altogether.
I have not seen the exceptions themselves, but from the wording used by the court, I would assume that they were exceptions to certain parts of the order. But the point I'd like to make there is, given that was not permitted, shouldn't that have been interpreted? If we're going to be very lenient, shouldn't that have been interpreted as basically their notice that they want to proceed to trial because they don't agree with the arbitration order in its entirety?
Maybe you're right. Maybe the Johnson and Levine does unconstitutionally interpret it. I wasn't on that panel. I haven't had a chance to address it. Maybe in this case I can't. But you're down to your 5 minutes, Mr. McKee. So use them as you wish.
I will save the rest for rebuttal and touch on the civil theft issue on rebuttal. Thank you.
Okay, Mr. Crockett, you look familiar.
Okay, I will. My microphone is on. Good. I won't repeat myself on the arbitration issue. I think essentially this is a very similar argument. I would just say the distinctions between the other cases and this case are all in favor of this case being a stronger case for respecting the right to trial. We have a finding from the trial court. It was stated on the proverbial record that the intention of plaintiffs was to proceed to trial, and they stated in court that they wished to proceed with litigation. This was not a case where the judge said, you have not filed the right thing, you need to, or I'm not going to set a trial. In fact, instead, again, everything is taken in favor of the trial court's decision, presumption of correctness. What was said is, yes, there's going to be a trial, and Don Tilsit says, give us plenty of notice. So again, the trial court was correct in that case. He said, Jody has said the remaining arguments will address the civil theft issue. He hasn't actually said anything yet, but what I would say is anything he's going to say is waived because there was no motion for directed verdict and there were no jury instructions submitted at all. So there was plenty of evidence. The jury instruction was correct. In their briefs, they complain about an instruction which said the existence of a contract didn't necessarily preclude a civil theft claim. They admit that's true. All the case law says that's true. And this was an embezzlement case. All the cases say embezzlement, even by an employee, is civil theft and conversion. So there was ample evidence to support the trial court did not abuse his discretion in the jury instructions, and there was no directed verdict, so we can't look at sufficiency of the evidence. So we would ask that as far as Jody, Joellen, and her entities are concerned, the court simply affirm the judgment in full.
Okay, thank you, Mr. Crockett. Mr. McKee, you got your 5 minutes.
Thank you, Your Honor. So turning quickly to the civil theft issue, as I mentioned earlier, this really was what should have been a breach of contract case. This was a dispute over contractual agreements between Ms. Tilsit and her entities and the plaintiff entities. The question there was
that some of these contractual agreements were, made up after the fact and the signatures forged.
There were certainly allegations to that extent, but I would,
and there were allegations made and then evidence presented.
With respect to certain of the agreements, one of the agreements that I don't believe there was any evidence presented about it being fraudulent or in any way.
The fact of creating those faux agreements after the fact casts some shadow on whether the parties were acting in good faith, whether they, under the actual agreements, whether, this was just, I accidentally overpaid myself versus I was stealing.
It certainly could, Your Honor, but let me direct you to perhaps one agreement in particular to at least help illustrate what my argument is. There was a particular agreement, a property management agreement, that I don't believe there was any finding that it was fraudulent or had never been created. The issue with respect to that property management agreement was that it contained brokerage fees that the other side alleged, Gondolier and Mr. Cassidy alleged, could not be recovered under Florida law because Ms. Tilsit did not have a brokerage license. The court there entered summary judgment and said, yes, I see this agreement, but these brokerage fees, she can't properly collect them under Florida law because she doesn't have a license. Therefore, those monies should never have actually been collected by Ms. Tilsit. That, in my mind, Your Honor, and I think the case law, that is never going to be proper for a civil theft judgment. Those several $100,000, $400,000 or $500,000, those should have been returned by Ms. Tilsit, certainly if she could not take them properly under Florida law. But civil theft is a completely different matter. So where you have two parties that have entered into an agreement.
So if that agreement had been valid and she had taken money that she wasn't entitled to ostensibly pursuant to it, she could be found to have committed civil theft. But if the agreement is not valid, she can't be found to have committed civil theft.
Well, no, Your Honor. I think if the agreement was valid, and I think the agreement, I don't think there was any challenge, or at least I don't think there was any finding that agreement never existed. That it was fraudulently created.
Right.
So if it's in existence, and I think for our purposes at least, I think we have to act as if that agreement was valid, so to speak. Meaning it had been validly created. When we get to the question of whether under Florida law she was entitled to collect brokerage fees, I don't think that can ever constitute civil theft.
Well, in other words, she performed the services for which she was remunerated, even though she was not legally allowed to be a broker. But my question to you is how are we what are we reviewing if you didn't file a motion for a directed verdict, or can you address the arguments pertaining to preservation?
Sure, absolutely, Your Honor. And I would direct you to the transcript, pages 1642 through 1647. And this is the portion of the transcript that relates to the jury instruction that was added by the other side, specifically relating to civil theft. And to begin with, I think on page 1643 of the transcript, line 9, it starts off by Ms. Tilsith's attorney saying, "Mine is the standard." What he's referring to there is this jury instructions. So this argument that no jury instructions were submitted by Ms. Tilsith's counsel, I would submit to you is contrary to the record. He certainly did submit at least the standard jury instructions. If you turn the page to page 1644, Mr. Garcia, who is Mr. Tilsith's counsel, Mr. Cassidy and Gondolier's counsel, talks about why he wants this contract language added to the jury instruction. He said basically that he doesn't want our side, Ms. Tilsith, to be able to stand up and say there's a contract, we're going to pay the money back. If you can have a contract, you can't have a civil theft claim. He says under the case law, yes, the fact that you have a contract doesn't mean you can't have a civil theft claim, and that's correct, but it's only partially correct. The Gersh v. Coleman case.
Is that you're describing the discussion about the jury instructions?
Yes, Your Honor, and there was a
as opposed to a motion for directed verdict.
Correct, and I don't believe there was a motion for directed verdict filed, but there was a specific objection to the jury instructions.
But they made the court they made the court aware that they thought this evidence was not sufficient. Well,
Ms. Tilsith's counsel specifically said, "I object, Your Honor. We have a standard instruction. It's not in there," meaning the civil theft contract language. They're spicing it up with things that's not standard. We have a standard instruction. There was a specific objection to the instruction that was given, and I would submit to you, Your Honor, that specific instruction that was given misled the jury. It did not advise the jury that where there is a contract, you need to go further. You can't just say, well, did she take money that she wasn't entitled to? Certainly in the brokerage instance, yes, the court found that she took money she was not entitled to. But was there a sophisticated scheme of deceit and theft, which is discussed in Gersh v. Coleman, or Kaufman, I'm sorry? The answer is no. There certainly was not, and there was no instruction to that effect.
Okay, time's up, Mr. McKee.
Thank you, Your Honor.
Thank you both very much. These are interesting cases that I'd like to be